Bismillah, walhamdulillah, wassalatu wassalamu ala Sayyidina Rasulullah sallallahu alayhi wasallam. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to our ninth class of an introduction to Islamic law. This is our second to last class and our last main content-based class. Now, today's subject, or at least today's subject was supposed to be Qawaid al-Fiqhiyya, Islamic legal maxims, and also uh, something brief about differences of opinion or respecting the differences of opinion. But what we will do is today we will talk about Qawaid al-Fiqhiyya, so we'll keep that as our main topic, and we will lightly touch on differences of opinion after the quiz in our next class. So as you know, the next class is going to be a quiz and then Q&A. But before we do that, we will quickly touch on some of the important points when it comes to Qawaid al-Fiqhiyya. Sorry, when it comes to differences of opinion. I think some people are having issues getting in. 1 second, let me resend this to the group. All right. Hopefully those that are having trouble joining, they can try again now. All right. So last class, we spoke about the maqasid of the Sharia. We spoke about the purposes or the objectives of the Sharia, of Islamic law. And we spoke about the 5 major objectives, and those are the protections that Islamic law aims to obtain through fiqh. So the body of fiqh serves to attain those goals. We also spoke about substantive law, so what Islamic law is consisted of, or what makes up Islamic law. We have ibadat, we have muamalat, acts of worship, we have finance law, we have business law, we have criminal law. These things make up Islamic law. And then we went and talked about procedural law in Islamic law, how those laws are applied in an Islamic system in a very brief sense. Today, like I said, we will be talking about Qawaid al-Fiqhiyya, the Islamic legal maxims, and our last topic, which is a very brief topic, it's a few points, we will leave that for after the quiz. And I'll talk a little bit about the quiz after we finish our discussion for today. So let us begin with a screen share. Hopefully everybody got the slides as well. Let me know when you can see the screen. Can you guys see my screen? Okay, I'm done. Qawaid al-Fiqhiyya. So Qawaid al-Fiqhiyya, we already know what the second part of this word is, fiqh, right? It relates to those laws that pertain to physical actions or physical laws, generally fiqh. Qawaid linguistically means foundation, something that another thing is built on top of. So the foundation of a thing. In the Quran, Allah subhanahu wa ta'ala, for example, he speaking about Prophet Ibrahim, he says that he's laid the foundations down, right? Meaning of the Kaaba, the house of worship. And in its technical sense, which is what we're dealing with, it is a legal maxim. So when somebody says qa'ida fiqhiyya, qa'ida is the singular form of it, qawa'id is the plural form. When somebody says this is a qa'ida, right, this is a principle of fiqh. This is a legal maxim of fiqh. So legal maxim is one translation. Another way we can understand this, it is a general principle. So a qawa'id fiqhiyya or qa'ida fiqhiyya is a general principle which governs a multitude of specific legal cases. Now, before we even begin, we'll preface this by saying that there are always exceptions to the general principles, right? These are general principles that govern Islamic law. And then I put a definition there by Sheikh Mustafa as well, just to give a different flavor here as well. It's important to remember, just like fiqh and just like many of the definitions that we previously did, many scholars have their own definition, which are similar to the general definition, minus a few words here and there, or adding a few words here and there. Ideally, what you want to understand, that it is a legal maxim. And what is a legal maxim? A legal maxim is a principle of law. So it's a statement that gives us an indication of what the principle stands for, what this principle contains. And you'll see as we go on today what these things are. So let's talk a little bit about the history of this subject within Islamic law. Now, we find during the time of the Prophet ﷺ that some of his statements are taken as legal maxims. So some of the statements, which means hadith, right? So some of these hadith from the Prophet ﷺ are seen as legal maxims themselves. So we take them directly from there, and then we apply that statement to many other cases by way of analogy. And as a subject, in a sense, the earliest works that we see are from within the Hanafi madhab. So we see the earliest beginnings of the subject of Qawaid Fiqhiyya, where we're using legal maxims and listing legal maxims, and then trying to extract fiqh from it, or trying to use it as a governing principle of fiqh, developing from the Hanafi system. Now, they're not developed in one specific period, rather they're developed over time. And again, they start within the Hanafi madhab, but the other madhabs catch on and they start developing their own sense of Qawaid Fiqhiyya as well. So now all of the madhabs are contributing to this field of Qawaid Fiqhiyya, these legal maxims that we have. Now, some of these are extracted from fiqh. So you have scholars looking at different fiqh rulings. Now, these fiqh rulings could be from the Prophet, they could be from, meaning the hadith, right? So the rulings that we find in the hadith, they could be from the companions, the fatawa of the Khulafa al-Rashidin, the founders of the madhab, and the great ulama, the great fuqaha, their fiqh opinions, and looking at them and seeing that, look, there's a general principle that we can, or a similar principle that we can extract from these opinions that are common. We find every time a case every time a case shows hardship, we see that the fatwa or the opinion shows ease, or it rules that the ruling should have some sort of ease towards it. So we can extract an opinion or a principle stating that whenever there's hardship, there's room for ease, or it necessitates ease, right? So then it becomes a qaida, it becomes a principle of fiqh. Now, others are the opposite way around. Others are, maybe the Prophet ﷺ said a hadith in which we understand a principle of fiqh, and then we apply it to other parts and aspects of fiqh as well. One of the latest official attempts, you can say, was by the Ottoman jurists during the Ottoman period in 1866 to 1867 approximately. It's known as the Majallat al-Ahkam al-Adaliyya. And the Majalla, you can find a translation online as well. There's many different commentaries available on it. It's a set of these legal maxims that the Ottomans wanted to, in a sense, standardize their laws. Now, obviously, the Ottomans, or not obviously, some people might not know, the Ottomans, their official madhab was the Hanafi madhab. So the Majalla is based off of the Hanafi madhab for the most part. Not entirely, but for the most part, it's a legal maxim tradition based within the Hanafi tradition. And then there's many other attempts and modern works as well from other madhabs as well, at the time of the Majalla and even after the Majalla. All right, so in Qawaid Fiqhiyya, you have hundreds of different qa'idas, you have hundreds of different legal maxims, but there are 5 major maxims, which are known as the Qawaid al-Kubra, or the 5 great maxims, the 5 major maxims. If you read the article that I gave regarding this topic, it goes through these 5 as well. So the first one is al-umur bi-maqasidiha, that matters are determined based on their intended meaning. So matters are determined based on their intended meaning. We're going to break down each and every single one of these and use some examples so we can understand. But this is the legal maxim. The legal maxim itself is that matters are determined based on their intended meaning. The second one is, they're not in any special order, al-yaqeen la yazul bil-shak, that certainty is not removed by doubt. Certainty is not removed by doubt. The third one is al-Mashaqqa tejlib al-Taysir, that hardship invokes ease. So when there's hardship, it invokes a necessary concept of ease. The next one is al-darar yuzal, that harm must be removed. And the final one of the major five is al-aada muhkama, that known custom or custom governs in a contract or in any situation. So these are the five that are known as the major qawaid. And under each one of these, you have many different qawaid. So generally, what you'll find is, and again, each work, this is a very large topic. This topic itself, Qawaid al-Fiqhiyya, legal maxims, is an entire class by itself. Within the Qawaid Fiqhiyya works, within the works of Islamic legal maxims, you'll find different classifications or different ways of organizing it. So the way we are doing it, we're taking the five major ones and then we'll classify smaller or other maxims within one of these major maxims that there is. All right, let's look at this first one. Al-umur bimaqasidiha. Now, before I even begin, does this remind anybody of any hadith or any Quran ayah or anything? Because these maxims are taken from the hadith, all of them. Or ayahs of the Quran as well. So does this one remind somebody of some verse or some hadith maybe that directly correlates or relates to this maxim? Go ahead, somebody can share a hadith. Right, very good. Actions are based on their intentions or on intentions. إِنَّمَا الْأَعْمَالُ بِالنِّيَّاتِ, a hadith narrated by Umar radiallahu anh, that actions are based on their intention. Very similar to this, that the umur, that matters, or al-umur bimaqasidiha, are determined based on their intended meanings. So now let's look at some examples and some other maxims. Sometimes I'll mention the maxims first because they might relate to a specific matter. Here we have under some other maxims, and again, these two are not the only ones. This is not an exhaustive list by any means. There's so many maxims that fall under al-umur bimaqasidiha, that matters are determined based on their intended meaning. But one of the examples that we have here, or one of the examples of another maxim that falls under this that we have here, is when you have a contract or contractual stipulations, they're determined by the meaning, not by the words. Now, this maxim itself is differed upon by the madhab. Not all madhabs agree to this specific maxim, but it's one of the examples that's under here. The Hanafis and majority of the Malikis agree to this maxim. The Hanbalis and Shafis have slightly a different view on this. But here, in terms of when you have a stipulation in a contract, or when you have words in a contract, right? What determines that contract? Let's look at the examples that we have. If I told you that, look, I'm going to give you this as a gift. I'm going to give you this as a gift. As long as you gift me $500. What do you guys think that is? Is that classified as a gift, or should it be classified as a gift? Because we wrote up a contract saying that I, Arkham Rashid, am gifting my iPhone to Muhammad, and Muhammad is gifting $550 to Arkham. What do you guys think that is? Is that a contract or is that not a contract? What do you guys think? Contract? No contract? Sale? I have somebody here saying that it is a sale, all right? And that's what it is. It's a sale. How do we know it's a sale? Because it has all the elements of a sale. I'm giving you an item in exchange for another item. That is the definition of a sale, right? That's the definition of a sale. A gift, there is no exchange. When I gift you this, I shouldn't be receiving something generally, right? So am I going to simply say that this was a gift, or am I going to classify it as a sale? Now, based on this, al-umur bi maqasidiha, we are going to look at the intent, or we're going to look at what are the stipulations. This looks like a sale. We will classify this as a sale, and we will not classify this as a gift. Again, this is in the legal realm. What about, here's another example. What about if I tell you that, look, I'll sell you my house interest-free, no riba. However, you have to pay me an additional fee of 50% or 10% or whatever amount. Is that a riba-free contract? There's no word saying interest, riba, usury, nothing, right? You're paying me a fee, or you're paying me a gift, a monthly gift additional to the amount that you're paying me for the house. What do you guys think that is? Is that going to be classified Islamically as a sale with riba, or is that going to be classified as a halal sale with additional gifts, just because we wrote that that amount or that percentage is a gift? With riba, correct. So it's going to be seen as riba. We are going to look at the purpose of that stipulation. We are going to look at the meaning, the intended meaning of that stipulation. What is it, right? That stipulation is riba. Therefore, this contract is not permissible, even if you write it is a gift, even if you write it is a fee, right? The reality is, al-umur bi maqasidiha, that matters are determined based on the intended meaning, right? Based on what they're actually being used for. Now, that's this first one, right? And there's many examples that can fall under this. Sometimes an intention generalizes something specific and specifies something general, right? So this is another qaida, this is another legal maxim that falls under here as well. All right, the second one, al-yaqeen la yazul bil-shak, that certainty is not removed by doubt. So this is very similar to the set of presumptions that we did. Many of the sets, or many of the presumptions that we did, they are related very closely to this concept, that certainty is not removed by doubt. If something is established through certainty, it's not removed by doubt. Now let's look at one of the examples here, right? Or let's look at some of the other maxims under here. The original status of a person is no liability. The original state of a thing is permissibility. The original status of a person is no liability. Al-asl bara'at al-dhimma, that the original status of an individual is the lack of any liability. Right? That's the original status. You are innocent. So here in the example that we have, innocence, the presumption of innocence. Now, let's say I say that this person stole from me, or this person did such and such crime. The presumption we will start with is innocence, right? And that innocence will not be removed unless it is removed by what? So we have two things. We have yaqeen, which means certainty, and we have shak, which is doubt. The only thing that can remove yaqeen is, in this case, what can remove yaqeen? Generally speaking, we need something that is certain. So certainty removes certainty, right? Evidence that is certain, right? Not just simply an accusation that's doubtful. And it goes back to our last session as well, when we were talking about criminal law, that when we see doubt, we reject the case, or we turn it down from the higher punishments because there's doubt in that case. And what certainty is, no liability or no crime. That's certain, that a person is innocent until they are proven guilty. So here, in terms of innocence, it will be removed. Your innocence can be removed by certainty, right? Or something very close. There's different levels of it, but something very close to certainty. You know, when they say the very famous statement, beyond a reasonable doubt, that statement is very applicable to Islamic law as well, that you need something that is beyond a reasonable doubt, right? That it reaches that level of certainty to remove the original status, which is established with certainty. Same thing with the original state of something is permissibility, al-asl fil ashya al-ibaha, the presumption of innocence, we just talked about this. Same thing with ownership. So now, let's say I own this iPhone, right? It's established in my possession with certainty. I'm the owner of it. If somebody's saying I sold it to them, they need to establish, they can't simply say, oh, he sold it to me, therefore it's mine, or that it's mine, right? They need to prove with something that has an equivalent level of certainty, at least, to show that this was sold to them. Maybe a receipt, maybe something, some sort of a payment showing into my account, a contract with my signature on it, agreeing to that sale, or whatever it may be, different ways of proving that. But the idea is you cannot remove something that is established with certainty with doubt. Now, this also goes back to the Hanafi methodology, at least, where they say that if a ruling is established with certainty, it cannot be removed by something that has or that is established with doubt in terms of the way they view the levels of evidence. So remember, we talked about mutawatir, something that has multiple chains, versus khabr ahad, which is considered probable, right? So that's one of the reasons why they say it cannot change it. Now, remember, we said the Shafi'is, they're looking at something different. They're looking at sahih or da'if when it comes to allowing a khabr ahad, something with a singular chain, confine something or change the ruling for something. All right, the next one. المشقة تجلب التيسير. Hardship invokes ease, or hardship calls for ease. Both are fine. So here we have two examples that I put under other legal maxims that we have. Again, these are not exhaustive lists. As you see, I even wrote some other maxims. Sometimes there's dozens of legal maxims that can fit under this major legal maxim. But necessity permits that, or it permits the impermissible. الضرورة تبيح المحظورات. And then الضرورة تقدر بقدرها. This is the second one. The necessity is confined by what is necessary. Now, these two legal maxims actually fit in the next one as well, so I put it there as well. You can classify them under both, which is fine. There's also another example that we can put under here, that when the situation tightens or when it narrows, then you are to widen it. Right? إذا ضاق الأمر, that when the matter is narrowed, then expand it. Right? Open up the options, and then when it expands once again, narrow down the situation in terms of what's permissible, and there's other things that fall under it. Now let's look at one of the examples here. Let's say a person has no access to anything else to eat except for pork, and they are about to die, right? We know that a person is allowed to eat haram food then, right? Whether it be pork or anything else. Pork is an extreme example, like that's the only dish you have when you're at the verge of death, but it becomes permissible. And the reason why is right here. Necessity permits that which is impermissible. It becomes a necessity because it's a life or death situation. And we know that necessity, الضرورة تبيح المحظورات, that necessity permits that which is impermissible. However, there's another principle or another legal maxim, another قاعدة فقهية that governs this قاعدة, which is necessity permits that which is impermissible, which is the one right under it. And necessity is confined by what is necessary. So let's say I'm life or death situation. The only thing I have in front of me is pork. And now, does it become permissible for me to eat this or not? Yes or no? Very simple question. Based on this legal maxim. Take a look at this legal maxim. Yes, right? So it becomes permissible. How much can I eat? Can I eat the whole thing? Right? Can I just what is needed? So you see how it works? So necessity makes that which is impermissible permissible. However, it's confined to what I need. It's confined to what I need. So enough for me to be able to survive, and then it goes back to the original ruling, which is impermissible. Same thing, let's say somebody is Let me think. Okay, here's a very good one. This is a contemporary mas'ala. We are not discussing whether it is permissible or not. So that's not the reason for this example. We are not giving a verdict on or dealing with whether it is allowed or not allowed. I want to clarify that before we get into this example. Student loans based on or riba based student loans, let's say that. So interest bearing student loans that we have. Now, the scholars that say that it is permissible because they classify it as a necessity and they have their legal reasoning why they get to that conclusion. Again, we're not discussing which opinion is valid, which is not, what's a stronger opinion or whatnot, but just looking at the example and looking at the reasoning. If we classify it as a necessity, so necessity would permit that which is impermissible. So if we classify it as a necessity that a person needs education for them to be able to provide, for them to be able to get a job or whatever it may be, right? So let's say we go by that. We say it's a necessity. We say, all right, it's permissible for you to take that loan. You have no other means to pay for your education. You're allowed to take it, right? A person takes it. How much are they allowed to take? Right? People tend to forget the second portion of, or the next legal maxim that governs this first one. الضرورة تقدر بقدرها, or تتقدر بقدرها as well. That it is the necessity is confined by what is necessary. So you can't take out loans that you're using to buy a car and do this and do that because you maxed out your loans. It's not permissible. Even based on the opinion saying that you're allowed to take out loans for your education, it doesn't include, buying all this extra stuff, or if you can pay the cost of that education by bare minimum, and that's all you need, and you can live in a cheaper housing or cheaper this or cheaper that. You need to go by those options because necessity is confined by what is necessary. And yes, that's correct as well, Brother Anwar. A local school versus a prestigious school, right, or a fancier school, those things have to come into consideration when making this discussion, because it's not a free-fledged thing that, okay, yes, necessity, therefore necessity makes that which is permissible impermissible. It's governed by other legal maxims that you have to confine it. Now, you can make arguments for very specific things here and there, but generally speaking, it's governed by that, so it has to be confined. Another thing that we have in contemporary fiqh is whether a person can buy a house based on interest loans, right, or interest-bearing loans. Now, again, we're not discussing permissibility or not, but we're talking about those who allow it. They don't allow it as a, go ahead, buy rental property and this property and that property based on durura. There is a heavy discussion on whether it would be considered a durura if you can rent, right? If you have the ability to rent, would buying a house, let's say a person, let me put it this way, the most extreme circumstance. A person does not have housing. They don't have housing. They don't have the ability to buy a house without interest, nor do they have the ability to rent. So now we are looking at a very specific situation. This person is not able to rent, not able to buy a house. They're homeless. The only option they have is buying a house with an interest loan. In that case, it becomes permissible. So in that case, taking that interest loan becomes permissible. Again, we're taking the very edge of it. You don't have the ability to rent this and that. Most of the issue comes whether a person has to rent or not. But let's say a person is not able to, for whatever reason, we are in this scenario, they can't rent. They're not able to, they're not getting approved, whatever it may be. So it's either interest loan and get a house, or you're on the streets. It's permissible Islamically in that case to then take that loan because ad-durura tubihu al-mahdhurat. It's impermissible generally, riba is impermissible because of your necessary situation, and that lack of housing is seen as a necessary situation by the Sharia. You are allowed to take that loan. Now, does that mean you can go and buy $1 million house? No, of course not. Does that mean that you can go buy a house with 6 rooms? Right? These things, it's not a free, ticket to do whatever you want. That here now, because you're in a situation that is deemed a necessity, you can do whatever you want. No, it's confined by what the bare minimum is. Now, again, this is not only dealing with things that are necessary and things like that, but it's also in terms of hardship. Whenever there's hardship, the Sharia provides ease. One of the other things that we have here is no qada prayers for somebody who's missed their prayers during, or no qada for prayers missed during their menstrual cycle. So if when a woman is on her period for the month, she does not need to, or she can't pray during that time, but at the end of it, she doesn't need to make them up as well, because it's considered a hardship, that if you're constantly requiring somebody to do that on a monthly basis. Now you might ask, what about the menstrual cycle during Ramadan? Right? Why does fiqh say that has to be made up? Because that's not seen as a consistent hardship. It's seen as a few days in the month of Ramadan. Now, if a person is missing the entire Ramadan for some reason, let's say they're pregnant or whatnot, there are different rulings, right? Some people see that as a hardship enough to say they can pay the money. Some people say no, that's not, to that level that it's consistent. So there's discussion on that. But here, the qada prayers, al-mashaqqa, hardship, invokes ease. So the Sharia eases this permissibility, or the lack of qada in this case, that you don't need to make up your prayers in those cases. And we see this in many different examples as well. When a person is traveling, they can shorten their prayers. When a person is traveling, they can combine their prayers. All of these rules fall under this hardship invokes ease. So these rules are there for that reason. When there's bad weather, the situation we're praying in the masjid, all of those rulings, they can fall under here. There's so many examples that can be given under here. But again, we are just briefly looking at these qaidas. I do have one case study at the end of this that we will walk through to see how this is applied to the full extent. And I chose a mas'ala, or an issue that is very relatable and very, very common for people. So it's something that we can benefit from as well. All right. The next one that we have, I think this is number 4, if I'm not mistaken. Yes. This is number 4. Ad-darar yuzal, that harm must be removed. So this is a general legal maxim that says whenever there's harm, it has to be removed. And this is, again, based off of the hadith of the Prophet ﷺ, saying that there's no causing harm, there's no reciprocating harm, right? There's a hadith from the Prophet ﷺ that kind of iterates this legal maxim. Some of the examples that we have here is the guarantees or the returns on an item. So you buy something, it has a defect. The fact that you can return it, these things are under this principle that when there's a harm, we must try to mitigate it or remove it, right? That's the idea behind this. We'll talk about this second example in just a second. Some other maxims that fall under this major legal maxim. When two harms are in conflict. So when we have two harms, the lesser is the one that we have to choose. So we have two harms, they're not equivalent, right? They're obviously, one is lesser than the other, or less of a harm than the other. We choose the lesser harm. And this is similar to the idea of the lesser of two evils, right? This phrase that we have, choosing the lesser of the two evils, this is very similar to that. Now, again, remember we said all of these qa'idas, all of these legal maxims or these legal principles that we have, they all have exceptions to them. They're not, applied in every single situation. Sometimes another policy might be a lot more important in a certain case, or there might be istihsan, for example. Remember, we learned those sources that a legal scholar can use and not apply this principle in a certain situation, saying it's not serving its purpose, it's not serving justice. But in a general sense, when two harms are in conflict, if there's a lesser harm, we go with the lesser harm. Harm cannot be removed by its equivalent. So if you have two harms that are equal, right, you can't use a harm to remove a harm, right? You can't use a harm to remove a harm. Let me think if I can think of an example right away. Nothing's coming to mind right away. I had one when I was writing these slides out. Okay, we'll get back to it if I remember one. The next one that we have here is specific harm takes precedent over general harm. So this is if there's a harm that is going to harm the whole neighborhood or everybody, um, versus a harm that will harm one person. So it will harm one person's house or something in the neighborhood. Then the specific harm is the one that is going to be applied, or the harm that you have to go with in terms of the general harm. And again, these are dire situations. If they're equal, then it won't be you won't be allowed to use harm to remove harm. Um, and then necessity permits that which is impermissible. We did this one in the previous slide. This can also be categorized here, that because when you're in a necessary situation, there's harm, right? So when I'm in a life or death situation, I will die if I don't eat this pork in front of me. In that case, the harm has to be removed. Therefore, it becomes permissible for me to eat it. So I have selling drugs to get out of poverty. Yeah, that might be one of them, but I mean, under you can't use harm to remove harm. I mean, it seems like you classified there, but I'm sure, once you start thinking about it, you might find loopholes and stuff. For example, what if somebody says, I have no other means of eating, life or death situation? Then does it fall under um, the lesser of two evils or whatnot? So, okay. Um, let's go to the second example that we have here, which is abortion of rape. So of a rape victim, or sorry, abortion after rape. It becomes prohibited after the prohibition period. So in Islamic law, abortion is there's a difference of opinion exactly when it becomes impermissible. But let's say right when it becomes impermissible, after the few weeks that they give, because there's a difference within the four schools exactly when that period starts, or even if it's permissible before and for what reasons and what will be permitted. But after the time that all schools agree that it becomes impermissible, are is a rape victim allowed to get an abortion? And here the scholars discuss based off of the qa'idas or the qawaid, the legal maxims that we have, the principles of fiqh, and they say that you cannot remove that. They acknowledge that this person, this victim, there's harm that's been done, but you cannot remove it by another harm, and another harm of its equal status by killing the baby, or by a harm that is considered greater. That yes, this person has been wrong, so they balance the harms in this situation. It's not that they're saying that, oh, we're neglecting this, but rather it's a situation of two harms, and they're discussing whether this is a greater harm or equivalent, and therefore they don't permit it. That's the majority view. There are dissenting opinions that we have in that case, but it's a extremely minority view. All right. Now, here's a question that just comes to mind with this mas'ala. Generally, the scholars, they'll allow abortion after, all the way to almost the end, if there's a certainty that the mother's life is in danger, that the mother will die. If there's a close to certainty for that, scholars permit it. Then that's pretty much the only reason that you'll find. If the scholar permits abortion all the way to the end weeks or close to birth, close to birth, this is probably the only reason that you find. Anybody know why? We just did this qawaid al-Fiqhiyya. You can use a qawaid to establish this. The argument that is made is that the mother's life is considered certain because she's already living. The baby's life is seen as uncertain in comparison to the mother's life. Therefore, the certainty, which is the mother's life, takes precedence. It is a fiqhi discussion. Now, again, there are dissenting voices on this as well, whether they consider any life to be certain or not. And that's a back and forth argument, not the topic of our discussion. All right, the last one. Known custom governs, or custom governs. And examples of this, or let's look at other maxims that fall under this. Conventional gestures is like speech itself. So a conventional gesture that you have in a society is considered to be speech. So and the example that we have for this is, if I say, do you agree that I buy this from you? And I go like this, right? Is that a yes or a no? All of us will say yes, right? That's based off of the custom. In our culture, or in our custom, if we do this, it means no. If we do this, it's yes, right? So you can't go to court and be like, yeah, I did this, but I didn't mean yes. They just thought yes for some reason, right? It will be seen as a yes because the custom will govern the situation. Now, in a culture where head movements are not considered to be the same, it'll have a very different effect. So you can do this all you want, but you don't have a contract. Another example that we have here is the established practice of a community, or another maxim: established practice of a community is equivalent to a stipulation. So within, let's say, we're all in the market for fish. Random example, we're all fisher men and women, and between us in our fishing community, it is known that if we say a certain term, it means this type of fish, or these three types of fish, or whatever it may be. So those terms and that terminology within that community, right, that will govern. That's the considered the custom of that community. So even if it's not explicit, it will govern. If I say I want to buy, or I want the fish delivered, and it's a custom for the fish to be delivered in a certain way, that customary practice will govern the situation. And I have dropping off of a package. Let's say let's say a company guarantees that your Amazon package is guaranteed to be delivered, and it is under our liability until it's delivered to you. But once it's delivered, it goes in your liability. Now, let's say the guy comes to your house and leaves it on the street in front of your mailbox. Is that the customary delivery place? Would that be considered now in your liability if they left it on the street in front of your house, or across your house, or by the park by your house, right? No, right? So those things in culture or in custom, generally they will govern unless it's stipulated otherwise. So unless I stipulate in a contract that my shaking my head yes or no will not be seen as a yes or no when we are discussing, right? If I stipulate that, then it goes by that. But if with the lack of any stipulation, the custom, the culture, that will govern the situation. So this also shows us how important culture or custom is seen in Islamic law, that it has an effect within the Islamic legal system, and it will determine the stipulations of your contract within the Islamic legal system. All right, so the case study we will do is that of broken wudu. All right, hopefully we finish before time. Not sure whether I have wudu or not. So this is a situation. I don't know if I have wudu or I don't. Here's the question. Do I have wudu or not? I'm not sure whether I have wudu or not. What's your answer? Do I have wudu or not? We're going to walk through this. So get ready to type or unmute and answer, whatever is easier for you. So I'm not sure if I have wudu or not. What do you think? Do I have wudu or not? Go ahead, put your answers in the chat. This is the last thing we're doing. We're doing this case study and we'll be done. I can't remember breaking it. Yes. I can't remember making it. No. Okay, brother Anwar, stop giving away the answers, please. All right, so I have some answers coming in. I have yeses and I have, no, you're fine. But we're walking through the masala, right? So we want to understand where that reasoning comes from or what's behind it. So do I have wudu or not? A lot of people are saying, yes, I have wudu. Or should I make wudu? So let's look at Let's look at a hadith of the Prophet ﷺ. In this hadith, what I want us to do is look at this hadith and see what principle you can extract from this hadith. So this is the hadith of the Prophet ﷺ. Somebody asked the Prophet ﷺ that a person who suspects if they broke their wudu or not during prayer, what should they do? The Prophet ﷺ said that that person should not leave the prayer. So this person is in prayer unless he hears a sound or finds a smell, right? What principle can we extract from this hadith? Or before we even do that, I put this here on purpose. Muttafiqun alayh. So what is muttafiqun alayh? Before we get to the principle that we can extract, anybody know? Muttafiqun alayh means agreed upon. But what does it mean when you find a hadith? And this is just general good knowledge to know. When you find a hadith and it says muttafiqun alayh, what does that indicate to us? That when it says agreed upon. Anybody wants to take a guess? Let me put it this way. Let me give you a clue. Agreed upon by who? This statement here, muttafiqun alayh, this is the reference. So, okay, so I have it, hold on, I have an answer here. All schools agree. But this is not the realm of fiqh, right? We have a hadith here, and in the hadith references, it says muttafiqun alayh. So we're going to look at the terminology of the muhaddithin. What do you think that means? You guys are on to something, right? You know somebody's agreeing. But who is it? When you say muttafiqun alayh, I'll narrow it even further. It means two hadith scholars have agreed. Or it's meet the criteria of two hadith scholars, in a sense. Bukhari and Muslim, very good. So muttafiqun alayh means that it is agreed upon by Bukhari and Muslim, meaning it's meet the condition of both of those hadith scholars, and you'll find this in Bukhari and Muslim. So this hadith is in Bukhari and Muslim. So it's just something good to know that if you see a hadith referenced as muttafiqun alayh, automatically it means Bukhari and Muslim. All right. Now this is going back to our fiqh question. What fiqh principle can we extract from this hadith? Very good. Certainty is not removed by doubt. Where do we get certainty from though? So that's good. That is correct. Certainty is not removed by doubt. Al-yaqeen la yazul bi-shak. Certainty is not removed by doubt. Where's the certainty? How do you know there's certainty in this situation? Okay, he had wudu. How are you implying or understanding that he had wudu? From the response of the Prophet. Right? So it's indicating that he shouldn't leave the prayer, or he shouldn't leave from praying. So we already know there's something with certainty that he had wudu. Okay, very good. So from this hadith, like many of the other Qawaid al-Kubra, the legal maxims that we have, they're all taken from hadith. Again, sometimes it's not explicitly mentioned word for word that the yaqeen is not removed like this or whatever it may be, but they're all understood from hadith and principles that we see the Prophet ﷺ. This is a fatwa, right? This is a legal ruling that the Prophet ﷺ is giving this person. That don't leave until you hear a sound or find a smell. Meaning don't leave until there's something equivalent to that certainty. So the ruling or the legal maxim that's being applied here is certainty is not removed by doubt. So we have here, right? Certainty is not removed by doubt. Now there's two possible scenarios. All right. Scenario number one, you had wudu and you can't remember if you broke it. So scenario number one is this. Let's say I prayed Salatul Dhuhr. I just prayed Dhuhr, right? And I made wudu, right? I made wudu, I prayed Dhuhr. And now after Dhuhr, about half an hour later, I'm like, let me pray some sunnah or nawafil. Now I can't remember if I broke my wudu. That's scenario number one. So I had wudu, I made it for Dhuhr, I remember making it. But I can't remember if I broke it between Dhuhr and that half an hour. That's what I'm doubting. Scenario number two is I broke my wudu. So After Salat al-Dhuhr, I went to the bathroom, I used the bathroom, so I know I broke my wudu. Now, an hour later, I'm thinking, let me pray some nafil or let me go read some Quran. And I know for a fact that I broke my wudu, but I can't remember if I made wudu in that time period between the time I used the bathroom and until now. These are the two possible scenarios a person can be in. So the first scenario is you remember that you had wudu and you made wudu, but you can't remember if you broke it. Second scenario, you broke your wudu, you can't remember if you made it. Let's look at scenario one. What do you think the answer is here? So I remember I had wudu. What is wudu in this case for me? I remember I had wudu. I made wudu. I remember making wudu for dhuhr. Which one is it? Is yaqeen wudu? Is wudu yaqeen or is wudu shak? Right. So certainty, which is yaqeen, and doubt, which is shak. Which one is wudu in this case? Very good. Certainty, right? So wudu is certainty. I know I made wudu. I remember it with certainty. I made it at dhuhr. The thing that I am doubting, the thing that is shak, is whether I broke that wudu or not. Right? So what is the ruling in scenario number one? That I made wudu, I had wudu, I remember making it, I can't remember if I used the bathroom, I can't remember if I broke that wudu. That's a shak. So what's the case? What's the ruling here? If somebody tells you, I remember making wudu for dhuhr, or you come to Asr prayer and you're standing there, you're like, oh, did I make wudu or not? I remember making wudu for dhuhr, yes. Did I break that wudu or not? In this case, do I have it? Correct, right? So yes, you have wudu. So case number one or scenario number one, you have wudu because what is established through certainty is that you had wudu or you made wudu. What you are doubting is whether you broke that wudu. So your doubting broke, you throw the doubt away and you remain on your yaqeen. Scenario number two, you broke your wudu. You're 100% sure you used the bathroom. What you're doubting is whether you made wudu or not. Right? You're doubting if you made wudu after you used the bathroom. Which one is yaqeen here? Like we said, using the bathroom. So breaking your wudu is yaqeen. The shak is whether you made it. Which one gets thrown out? The shak, the doubt. So in this case, in scenario number two, do you have wudu or not? No, you don't have wudu. You see how it works? So here's your answers, right? So in the first one, still have wudu because wudu is certain. And since wudu is certain, certainty is not removed by doubt. Scenario number two, you do not have wudu because the lack of wudu is certain. You are certain you use that bathroom, and certainty is not removed by doubt. All right. So that pretty much brings us to the end of today's session. Like I said, it was supposed to be two subjects, but I wanted to focus on this subject and not go over time. So the brief points that we have about differences of opinion and understanding and respecting them, we will do it after the quiz. Before we open it up for Q&A, next week we will begin the class with a quiz. The quiz is nothing complicated. It shouldn't be hard. I would advise to revise your notes if you have notes, or if you have time during the week to go over the at least the 8 lectures, not including today because you already heard this, at a faster space or pace if you want. It is not open book. You can do it. I mean, you're not really issued a grade or anything like that. It's for self-evaluation. I wouldn't do it open book. It's not. It's going to be all multiple choice or true or false. So it's not something that is going to be taking a lot of time or very complicated. However, for those that would like extra time, in our next session, I will begin the Zoom meeting 20 minutes before the actual class time. So we start at 6, so I'll begin it at 5:40. And for those that need extra time, they can jump on at 5:40 and they can start doing the exam there. Ideally, I will have it on the Zoom poll thing. So I will try to insert it into the Zoom poll. Sometimes it lets you do a limited amount of questions. So if I have more than that, we will give an allocated time, which I will send in a text message at least a day before the exam as well. So don't worry, it's not going to come as a surprise. But those who need extra time, you will have extra time prior to the exam, not after. So you can join 20 minutes before. We'll start the quiz. I will also send a PDF copy of the quiz for those that want to do it there. But if we're going to do it on Zoom, I'd recommend at the end you enter your answers so then we can share the results. It's anonymous, it won't have your name on it. And you will be able to see what majority of the people answered for this. I can try Google Docs. I haven't tried that for quizzes, but if you show me how, I'd be interested in doing it that way as well. I don't mind. So maybe we can talk at Juma or something, and that could be a possibility. But something that will give us a result. But okay. I think like a Google form maybe. Um, I'll talk to you inshallah after class. We can see. So that could be a possibility. I know how to do the forms. So for the quiz, 20 minutes before you can jump on, and you will have that extra time. Ideally, the quiz will go on until we'll start at 6 officially. Extra time is before 5:40, and it will go on likely to 6:30 latest. So it's not a long quiz. It's only going to be maximum 20 to 30 minutes. For those that need extra time, they can have that extra time. And then we will go through the quiz, we'll revise the questions and go through what's the reasoning behind the answers. And then we'll do the last topic, which will be differences of opinion. There's just a few points about it. And we will end our session with that, inshallah, and with Q&A as well. If you guys are interested, I can also send a Google form for Q&A that you can pre-write your questions in, and we can cover those as well. So I could do that as well, inshallah. Or you can ask, as we usually do at the end of this. I think I covered everything in terms of the quiz. Again, it's I don't want you to feel pressure, but it's a good time to revise just so you get an idea of it, and just so you have a general sense of how much you picked up and how much you learned. So try to go over the notes, try to go over some of the key terms, right? Those are important key terms. Try to go over some of the major concepts. I'm not going to ask very specific things, maybe 1 or 2 questions, but it's going to be a very basic quiz. And again, if you have time, I would go through the lectures again before the quiz, just to refresh everything, maybe at a higher speed. And also even after the quiz, it's good to go over all the lectures that we have recorded. The last thing I will do before we do Q&A is just share a book with you, as we've been doing. This is a book on Qawaid al-Fiqhiyya, Islamic legal maxims. It's by one of the authors that I shared before, Dr. Imran Niazi. Now this book is slightly structured different from the Arabic books that are there, but it's not a bad beginning point. I don't know many Islamic legal maxim books in English. Majority of the ones that I'm familiar with are the Arabic versions, but this one seems to be this is very extensive. It's a lot more than you need for the Qawaid, but it's not a bad book to start with if you want to read into Islamic legal maxims. Okay, so let us